The next speaker will be Professor Bhagya Wickramasinghe. Bhagya Wickramasinghe holds LLB in Honors in the Faculty of Law at the University of Colombo. Currently reading for an LLM at the University of Colombo and an attorney at law. Currently, she's also a lecturer at the Faculty of Law at the General Surgeon from Lankan University. The title of the presentation is Lead Workery, an analysis of white-collar crime in the Sri Lankan context. Please welcome Bhagya Wickramasinghe.
Good morning, everybody. Today my topic is Need of Peace and Analysis of Judicial Response towards White-Collar Crimes in Sri Lanka. On my topic, I would like to mainly draw your attention to the fact that this topic was derived from criminological theories that enlist white-collar crimes as crimes that emanate due to greed rather than need. The outline of our presentation is basically to identify the research objectives and then to move on to the nature of white-collar crimes and the social and economic cost of white-collar crimes in terms of the consequences of particular crime. Thereupon, I would study the legislative response towards white-collar crimes in Sri Lanka, what are the laws that have been enacted in order to combat white-collar crimes, and the judicial response towards white-collar crimes. Basically, my research paper is based on the last two elements of this presentation. My research objective was to identify whether there has been any jurisprudence developed by the judiciary, especially the Supreme Court of Sri Lanka, which sets the jurisprudential ground, whether there has been any particular jurisprudence developed by this court in order to identify and combat white-collar crimes, because it has been identified by criminological theorists that in the recent years it is actually the white-collar crimes that have caused a lot to the society and economy of globally. The methodology is based on primary data where the legislative enactments are analyzed and thereafter the case law, especially in terms of the penal code, has been analyzed. The reason I picked the case law based on the penal code is mainly because there is next to no cases based on the other legislative enactments based on white-collar crime. In defining the white-collar crime, there has been a difficulty that has faced by criminological theorists in terms of defining and putting it into a watertight compartment as the other crime. And the main problem is that even in Sri Lanka, we have, the first few years, we have identified white-collar crimes as offences against property rather than this particular label. And the problem is, as you can see, in Sri Lanka we have failed to identify that white-collar crime actually falls into three basic categories as identified by Professor Sutherland. Namely, there are occupational crimes committed by professionals. These are professionals engaged in various trades, and economic offences, basically fraud and embezzlement, which you might all know because due to the United States, and the corporate crimes. Corporate crimes, of course, we have suffered with a number of corporate crimes which have been attempted to be combated through the Companies Act rather than any offences. So, whether corporate crime should be recognized as a specific crime, that's a question I pose for you. In terms of the cost of the white-collar crimes, as you all know, the cost is well to be seen in the society, but whether it can be identified in terms of the injury. For instance, in murder, you can easily identify the murder victim and the victim's loss. But in terms of white-collar crimes, it is a little more difficult and the cost is most of the time hidden. And the social cost of the society is also hidden in terms of the grief suffered by the victim, and in terms of the economic and the emotional cost to the victim might be much more harmful than a simple grievous hurt or a murder, where the murder only is committed against the victim, where the victim is the only victim victimized person in white-collar crime, the offense victimizes numerous parties, including the victim's family, the society, and ultimately the economic culture. In terms of the legislative response in Sri Lanka, I should mention that we have a very thorough substantive ground in terms of laws, because we have established all the laws that are necessary to combat this crime. Apart from the penal code, which of course recognizes various types of crimes against property, we also have the Prevention of Money Laundering Act and the Payment Devices Fraud Act, the Computer Crimes Act, and Convention on Suppression of Terrorist Financing Act. In terms of, I would like to draw your attention to two of the acts that are mentioned here. Basically, the Prevention of Money Laundering Act and Payment Devices Fraud Act, especially in terms of Payment Devices Fraud Act. This can be used in numerous occasions where offences against credit card is committed, and credit card time is in the right, and it is always seen in the society. But whether it is seen in the court, whether it goes to the court is the question, because this act is not being implemented effectively by the prosecutors, lawyers, etc. So in terms of the judicial response to white-collar crimes in Sri Lanka, I have identified through my research that the penal code has numerous grounds and numerous offences that have been identified in terms of mischief, fraud, and, as I have mentioned, cheating, criminal breach of trust, etc. In terms of these offences, the judiciary has attempted to define these crimes, define the elements of these crimes, rather than move into a jurisprudence of combating this crime and identifying the nature and gravity of white-collar crimes. On the other hand, the problem remains that majority, as stated by the grave crime indexes of Sri Lanka, the majority of crimes that are being investigated and identified by the police and the prosecutors is based on the penal code, rather than all these acts that are mentioned after the penal code that actually has more capacity to combat white-collar crime. So whether the problem remains that the people on one hand, and on the other hand the criminal justice system as a whole is unaware and is a little unwilling to move away from the penal code where their comfort zone lies and move into the new acts that have been drafted by the legislature identifying the problem in the society, and they have not moved into these new laws that have been made, and they are not using it effectively in order to combat white-collar crime. So, reaching a quick conclusion, I would like to say that our criminal justice system, if it is to combat white-collar crimes and prevent sagas like the subsidy incident and Selimco and all these issues that we have come across in the recent years, where victims suffered suicides and families were caused so much of loss, and the society was so burdened, and it caused a huge economic burden on the financial institutions and on the society as a whole, and on us, on each individual person living here is affected by these white-collar crimes. So based on that, there is a need for us to move more proactively in combating white-collar crimes, and especially in those terms, the judiciary needs to be more proactive. And in order for the judiciary to be proactive, there should be the lawyers, the police, and the public should be more